This video was created and brought to you by ManageMax. We manage condominiums, HOAs, manufactured housing and apartment communities throughout Southeast Michigan. We're a growing company, and maybe we'll get to your area soon if we're not there yet. We create these videos to share industry insights with current and prospective clients. There will be an opportunity to connect with us at the end, so stick around to the end of the video. Now let's dive in. A friendly neighbor dispute just cost this HOA $85,000 in legal fees. The board never saw it coming. What started out as a complaint about a barking dog turned into harassment claims, discrimination lawsuits, and attorney fees that ate up community reserve funds. If you're a board member for an HOA or condo association or an owner of an apartment community or housing park, this could happen to you. I'm going to show you how to spot the warning signs and protect your community before small conflicts become expensive legal nightmares. The biggest mistake I see community leaders make is treating every complaint the same way, but some resident conflicts have red flags that scream, this is going to get expensive. First, watch for pattern complaints. When the same resident files multiple complaints about different neighbors or issues within a few months, that's not normal community engagement. That's someone building a case. Second, pay attention to language escalation. When the complaints go from my neighbor's music is loud to my neighbor is deliberately targeting me, you're moving from a noise issue to a potential harassment claim. Third, look for documentation requests. When residents start asking for board meeting minutes, CC&Rs, or management contracts, they're often preparing for legal action. This isn't always bad, but combined with other red flags, it's a pattern you need to recognize. The key is understanding that some people use community disputes as leverage for bigger agendas. Maybe they want to get out of a lease, challenge a fee, or they're dealing with personal issues and looking for someone to blame. When you recognize these patterns early, you can address the real issue instead of just responding to complaints. Here's what most leadership teams get wrong about documentation. They either don't document enough or they document too much of the wrong stuff. Every complaint needs a paper trail, but not every conversation needs to be recorded. Focus on facts, dates, and actions taken. When Mrs. Johnson complains about the landscaping, don't write, Mrs. Johnson was very upset about the bushes. Write, Mrs. Johnson submitted written complaint on March 15 regarding hedge height. Management responded on March 17th with community guidelines reference. Always document your response and timeline. Courts don't care if you eventually fixed the problem. They care if you followed proper procedures and responded in a reasonable time frame. Here's the critical part. Never put opinions, assumptions, or personal observations in the official records. The moment you write, this resident seems like they're looking for trouble, or I think they're just being difficult, you've created evidence that can be used against you. And photograph everything. Property damage, code violations, safety issues. Visual documentation is your best friend, but make sure photos are dated and stored properly. A blurry phone picture from someone's personal device won't help you in court. The most expensive words a community leader can say is, "That's not our problem." Even when you're technically right, dismissing residents' concerns often turns manageable issues into legal battles. Successful de-escalation starts with acknowledgement. You don't have to agree with every complaint, but you do need to acknowledge that you received it and take it seriously. We understand your concern about the parking situation and will review it at next week's board meeting. Works much better than parking is first come, first served. Set clear expectations about process and timeline. When residents understand how decisions get made and when they can expect responses, they're less likely to escalate. Mystery and silence breed frustration. But here's what backfires: trying to mediate between arguing neighbors yourself. Board members and community leaders aren't trained mediators, and you can accidentally create liability when you get involved in personal disputes. Instead, refer them to community resources or professional mediation services. Also, avoid making promises you can't keep. "We'll look into it" is better than "we'll fix it" when you don't control the outcome. Broken promises turn disappointed residents into angry ones. Look, resident conflicts are inevitable when people live in close proximity, but expensive legal battles aren't. The difference is having systems in place to recognize warning signs, document properly, and respond professionally. Most community leaders learn these lessons the hard way after they've already paid the legal fees, but you don't have to. With the right approach, you can protect your community and your budget while maintaining good relationships with residents. Remember, an ounce of prevention is worth $85,000 in legal fees. If you found this perspective valuable, we invite you to connect with us. Facebook viewers, like our page and follow us for regular updates. Feel free to message us directly with your questions or community challenges. Instagram viewers, hit follow and feel free to DM us with your questions or community challenges. YouTube viewers, subscribe to our channel and check out the video description for helpful links. Visit our website to discover our thought leadership content, books, and resources that can transform your community management approach. Whether you're dealing with the challenges we discussed today or other community issues, we're here to help. Thanks for watching, and we'll see you in the next video.